Hello, everybody. How is everybody today? Okay, so what I'm going to do is there's been some filings that have gone on in the Chad Daybell case. We're going to go over those. If you have not subscribed, I'm going to ask if you please hit that subscribe button, hit the notification bell so you are made aware when I go live and bring information out like this. Okay, so as we see here, I'm going to share my screen. Okay, so as we see here, back in February, John Pryor filed some things with the court, and I'm going to briefly go over those. So this is in support of a motion for severance. So he's filed a motion for severance. Okay, so the first part of this is just basically him citing other cases and stuff like that. And I will jump right to the meat of it. But it says, come now, the defendant, by and through his attorney, John Pryor, and hereby submits this memorandum in support motion for severance. He cites the applicable law here. So if you do want to read through this, I will scroll through it so you can pause it at any time and you can read through it. He's just citing some other cases and just basically giving some his own feedback here. So this, you can pause it at any time and read through it. It's just other cases that he's citing. And we'll get to the argument. Okay, so this is his argument to sever. The defendant, Chad Guy Daybell, is scheduled for a trial commencing in early January 2023. At the present time, co-defendant Lori Vallow Daybell has her case stayed. Counsel for the defendant, Chad Guy Daybell, has not been provided medical information or any updates as they relate to the defendant, Lori Daybell. It is presumed by this counsel that at the time of this memorandum, her status has remained unchanged. So that's as of February 9th. The difficulty in preparing a defense and doing the necessary preparation when there is uncertainty as to whether one of the co-defendants will be present for trial creates a number of evidentiary challenges. In addition, preparation as it relates to asserting the defenses further complicates his case. I think that should be his case, given the severity of the charges. In the event that she is deemed unavailable because of her status, the defense would need to file several motions to exclude evidence as it relates to only defendant Lori Vallow Daybell. In addition, evidence under 404B as it relates to the defendant Lori Vallow Daybell as to other crimes, wrongs, or acts as would need to be addressed by the court. An evidentiary ruling would need to be made prior to trial. The outcome of such 404B evidence ruling would be based on whether these cases are severed or continue to be joined. The prejudice of these other wrongs or acts by Lori Vallow Daybell would certainly have an impact on jurors, and these cases remain joined. Should these cases remain joined, Counsel for defendant Chad Guy Daybell will not address specific evidence as it relates to this case in terms of prejudice to this defendant. Defendant Chad Guy Daybell would request that the state be ordered to present to this court in-camera statements and or other evidence it intends to offer from either defendant for the court to conduct the necessary analysis. However, the fact that defendant Lori Vallow Daybell's case status is uncertain. At least in one other instance, she is facing serious charges out of Arizona. Now, those are the charges she's been charged with: the murder of Charles Vallow, and that her other behavior would have a significant impact and prejudice the defendant, Chad Guy Daybell, when the court uses the three prongs as set forth in Fields and Nava. The defendant, Chad Guy Daybell, would be prejudiced by other wrongs or acts attributed to defendant Lori Vallow Daybell in her individual capacity, despite the fact that Chad Daybell is not facing the same scrutiny. The level of discovery in this case is beyond significant. The 3 prongs of prejudice would all apply to this case for defendant Chad Daybell. The defense again asserts that once the state provides the court with the information set forth in ICR 14, the court would clearly see how not only all 3 prongs of prejudice are evident as it relates to defendant Chad Daybell, but given the severity and nature of this case, it is even more important that the court err on caution and sever these 2 cases. Wherefore, defendant respectfully requests that this honorable court, pursuant to ICR 14, sever the 2 cases between these defendants. Okay, so that's what he filed. So next we get the order. Okay, for the defendant's motion to dismiss. Now, there's no other filings in this case regarding the defendant's motion to dismiss. There's nothing on file that I can see. And the reason for that is because there's information in there that has been sealed in other hearings. So whatever he is bringing up as reasons or evidence that they've come across or whatever that may be, that he's going to use in his motion to dismiss, he's saying that I can't put it here. I need an order to seal because there's information in there that's already been sealed at other court events. Okay, so it's hereby ordered that the hearing on the defendant's hearing on the motion to dismiss shall be heard on March 23rd at 9:30 a.m. The motion to dismiss shall be filed no later than March 9th. Now, I do believe that he has filed his motion, but right now, this is why we are not seeing it. Okay, so he also filed a motion to seal. And this was filed on March 8th, motion to seal. Comes now the above named defendant, Chad Daybell, by and through his attorney of record, John Pryor, and pursuant to ICAR 32I1 and 2, and moves this court for an order temporarily sealing the motion to dismiss the indictment with accompanying motions to disqualify the special prosecutor Wood and prosecutor Smith, and motions for disclosure. For until such time as the court may review the defendant's motion and make a determination as to whether the contents of the defendant's motions should be sealed from public disclosure and whether the court wants the hearing sealed as well. The court has previously entered an order regarding disclosure of information. The defense is complying with the court's order by requesting the motion to dismiss indictment and other accompanying relevant and related to the motion to dismiss be sealed based upon the court's prior order. For purposes of complying with the present order, the defense seeks a temporary sealing of the motion. So what this is it's not going to be put into the record where we can see it, because there's going to be things that are brought up in there that are already and have already been sealed in previous court proceedings with this same matter. So he is going after, like I said up here, let's go back. Okay, so he's asking for, it appears that the defendant or the state is prejudiced by a joinder of offenses or the defendant in a complaint, indictment, or information. The court may order the state to elect between counts, grant separate trials of counts, and grant a severance of defendants, or provide whatever other relief justice requires in ruling on a motion the defendants for severance. The court may order the attorney for the state to deliver to the court for inspection in camera any statements and confessions made by the defendants, and that the state intends to introduce evidence at the trial. So the motion to dismiss this whole case is going to be heard on the 23rd. So the motion to dismiss, the motion, if it's not dismissed, they want a severance. And they also want Prosecutor Wood and Smith taken off this case. So that is all going to be heard on the 23rd. So the judge did file a response and he did order to seal it. So based upon the motion to seal filed by the attorney for defendant Chad Guy Daybell and the previous order entered by this court, the defendant's motion to dismiss indictment, 3 separate ones, motion to disqualify Wood and Smith, and the motion for disclosure shall all be under seal. So what does that mean? That means that we are not going to hear any evidence or any accusations or anything that they want to bring forward in their motion to disqualify Wood and Smith. We're not going to know why they want Wood and Smith disqualified. It's all under seal. Also, the motion to dismiss the 3 indictments against Chad is also not going to be available for the public. It is also under seal, and so is the motion for disclosure. Now, I believe that the motion for disclosure, they want the reports, and this is what I think so far by reading through all this, is I believe that they want access to Lori's reports from the psychiatric hospital that she's in. We all know that there was some filings in her case, that there was some letters, evidence, whatever you want to call it, sent from there to the prosecution and to the court. So I believe that that is what they want to get their hands on, is whatever those disclosures were that they made and sent, whatever evaluation reports or whatever they sent from the hospital to the court. I believe that that's what John Pryor is asking for. They want that. They want that information. So being that all that has already previously been sealed, that's why everything here is being sealed, because they don't want us to see any of that information. And also, I would assume that there's something that John Pryor thinks is going on for him to ask for Chad to be charges to be dismissed on all his indictments, all 3 of them. And then there's going to also be evidence that they think they have that gives reason to disqualify Prosecutor Wood and Smith. So until the judge makes a decision on that, we're not going to hear anything more about this. So we still have not heard, I checked the records this morning, we have not heard anything new on Lori. It does still state that she is in, excuse me, the facility being treated. That's all we can know at this point, and that's all I can see at this point, is that she is still in that facility. She has not been brought back to the jail yet. So that leads us to believe that she has not been brought back to competency yet. So that's the information that I have for you guys. I hope everybody is doing well. I did do this without everybody coming in the live, just so I could get through this, because I am trying to catch up on all my reads, but I thought that you guys would want to hear about this. So that's where things are standing now. I do believe that I had it marked down for Chad, hoping, let me just see here. Yeah. So I was prepared to go on Wednesday, the 23rd live and bring you this, but that hearing has now been sealed, so I cannot stream it. I'm just writing a note to myself there. I cannot stream it because it has now been sealed. Now, March 18th, Chad is supposed to be in court. Letitia is in court on the 17th, which hopefully I can stream that. I will be going live with that at 10:45 a.m. on Thursday for the Letitia Stout thing. And hopefully we can stream that. If not, I will have the information that's coming out of the court on that. And then on Friday, the 18th, Chad is going for other motions. So I don't know if we will be able to stream that. I don't see why not. I have not heard anything regarding this. I think this is about the jury and the sequestering of the jury and stuff like that. I think it has to do with the motions that the prosecution has already brought up about transferring, picking the jury in Ada County and just bringing them to Fremont County. So I believe that's what that is all going to be about. If I can stream it, I will. I will be here live. And that is going to be at 11:15 a.m. 11:15 a.m. my time. I will be online in case we can stream that. If not, I should be able to get information that's coming out of the court there too. So we'll see how that goes. But right now, those are the two that are coming up this week. Thursday at 10:45 a.m. I will be live with the Letitia Stout pretrial readiness conference. And then on Friday, 11:15 a.m., I will be live again with the Chad motions, and I believe that's regarding the jury polling and picking and all that stuff. And that is 11:15 a.m. my time on Friday. That's all Eastern Standard Time. Okay, so until the next time, you guys, please take care of yourselves. Please stay safe. Bye-bye for now.